Hi everyone, my name is Michelle Hang. I'm the founder experience lead here at Grid 110, and I'm just super excited for today's session with Stephen and Johanna from Sparring. If you're new here today, welcome. If you don't know what Grid 110 does, we are a 501c3 nonprofit based in Los Angeles, and we provide entrepreneurs with access to community, mentors, and critical resources through no cost, no equity programs. I am super excited today to introduce to you Stephen and Johanna from Sparring. They are an awesome community partner, and I'm going to let them brag about what they do. So Stephen and Johanna, take it away.
Thank you very much, Michelle. Thank you for the opportunity today to speak with the awesome Grid 110 community. Some of you may have attended our session back in April or watched the recording since then. So thanks for coming back. I'll give you a quick background on our firm. I'll introduce myself, then Johanna can introduce herself. Afterwards, we will get into the content. So quickly, Sparring's a law firm built for startups. We operate and think like a startup and have that founder mentality. We really like to roll up our sleeves and understand the business that our clients are trying to build. So in that we join your Slack channel, we offer a subscription service. We have some ways of operating that are non-traditional for law firms, but that we feel better service the startup community, particularly those at the earlier stages, as many of you are at. So if after this presentation, any of you have follow-up questions or want to consider utilizing our services, I dropped my LinkedIn in the chat. Feel free to reach out to me or Johanna. Quick about me, I'm originally from Buffalo, New York, but have lived out on the west side of LA here for the last 5 years, practicing law in California. I was initially licensed in New York, so got licensed out here as well after I moved here and decided I wanted to stay. And so I had to get my license, and have been with Sparring now for almost 2 years. We are initially a European-based law firm, but they hired me to open our US branch a couple of years ago, and we brought Johanna on in January to bolster our team. And I will let Johanna take it from there.
Yes, thank you. Well, I'm Johanna, and I've been practicing law in Los Angeles for almost 10 years at the end of this year. I'm originally from France, but I've been in Los Angeles for 18 years. I have a more traditional transactional background in terms of legal practice. But over the last years, as startups have developed a lot in LA, coming from Northern California to here, I get to help out a lot more startups and find that it was more fulfilling as an attorney to help startup through the different stages. So when I had the opportunity to join Sparring, then it was a no-brainer. So I'm happy to join there, and happy to help the community today and answer the questions that you have posted. So I mean, startups can be, it's a one word that has many components, especially based on the different stages of financing or development of the startups. And it can be sometimes a little bit not intimidating, but scary, because there are many steps, and it's always good to start with the right steps. And hopefully we'll be able to guide you today on this level.
Thank you, Johanna. So quick disclaimer that nothing in today's presentation should be considered legal or tax advice. This will instead be a broad overview of some common pitfalls that founders face. Any decisions you are making on behalf of yourself or your startup, please consider consulting with a legal or tax professional. So on to our presentation. Thank you for sending in your questions beforehand. Our last one, we did a slideshow, and it was more of a sort of 101 nuts and bolts of startup law. Today, we're going to gear this conversation more towards the questions that were submitted beforehand. So thank you very much for those. Anything that was duplicate, we tried to roll into one question. There were a couple that came in that were maybe a little too detailed or specific, and that fall outside of the scope of today's conversation. So if you find that your question wasn't covered, that might be the reason. But otherwise, if you feel that we missed your question, or you have follow-up question, of course, let us know. And we'll try to do this first part in about 30 minutes. So we do have time to go through the AMA style format at the end. So Johanna, I will let you take the first chunk here.
Sure, thank you. I think it's so one of the questions that came a few times is the corporate structure for a startup. And this question comes often. Do we do a corporation? Do we do an LLC? Where do we organize the entity? And this is a very good question, because this is the beginning of the corporate journey for the startup. There are really two aspects to it. First, it's a question of taxes, and then it's a question of corporate law. So usually the way we see it a lot is if you're a startup and you, as a startup, you foresee having investors in the future, which is often the whole purpose of having a startup. Investors will not invest in an LLC. They invest in corporations, and this has to do also with the tax implication of having an LLC, which is usually taxed as a partnership. So that's why they tend to go with corporations, which are creature of statute, and LLC's creature of contract. So investor would prefer to have the set rules of the corporation. It just gives more visibility, predictability, and the corporate structure is more formal for a corporation. So that's the one. Very often, even if we have clients who have like an LLC and they want to raise some funds in the future, we usually recommend switching to a corporation. And then also, so that's the big that's what we see, and this is usually what happens for startups. I mean, aside from the tax aspect, I don't want to go too much in tax advice because I'm not a tax professional. But just keep in mind that at least like the corporation is taxed at the corporation level. And as opposed to an LLC, which as a partnership would be taxed at it would be like a pass-through entity. So these are like the main difference between the two. And in terms of where to incorporate, well, as everyone knows, Delaware is the big star in terms of the preferred state. And this is due to the fact that, first of all, it's very easy to incorporate in Delaware, but their laws are very pro-business. They have very well-crafted precedents, meaning that over the last 30, 40 years, corporate law has really developed in Delaware. Their judges are very sophisticated in terms of business disputes. And it also provides a sense of comfort for investors and companies, because they know that if there is a dispute, it won't go a weird way, or which could be sometimes the case in different states, such as California. So that's why Delaware remains the preferred state of incorporation, and especially for investors and therefore for startups.
Yeah, and you know, there was a question specifically about which states. So like Johanna said, Delaware is generally the preferred location for startups looking to get venture investment, which most of you will be. If you want to consider California, or if you are in another state, it's the way I think about it is, if you have a business that you truly plan on keeping within the state lines, then it might make sense to register your corporation in that state. But otherwise, Delaware generally makes the most sense. Wyoming is becoming more and more popular because of some crypto-friendly regulations and some other what we would say are looser restrictions on corporate activity. But while that might seem like a nice option because it gives you some more flexibility. It also could be a red flag to an investor wondering why you've registered in Wyoming. So generally speaking, Delaware. I just saw a question come through the chat as well. So as part of this answer is that regardless of where you register your corporation initially, you will also need to have a business license in the states in which you are conducting business. So for example, if you are in California and you file for a corporation in the state of Delaware, once that corporation is filed there, you will then register as a foreign corporation in California. And you'd likely also be applying for a local business license. But in terms of the state registration, you would do that at the state corporate level, filing with the California Secretary of State. So a related question that came through was regarding assessing the viability of incorporating if you're a bootstrapped startup. So what are some miles and triggers that might justify the expense of incorporation? So Joanna and I were talking about this the other day, that my default to tell founders is to incorporate as soon as you can. As soon as you think you are going to follow through with this business, incorporate. However, that's not always a financial reality. So some other things to consider. Firstly, are you signing agreements in your own name? So have you created this business, but because you don't yet have a corporate form, you are signing things as yourself? This could potentially expose you to liability. So it's better to have a corporation to protect your individual liability if the corporation is acting in some way. So if you are signing contracts, if you are selling a product, if you are bringing other people onto the team, these are all things that you generally want the corporation to be the one doing the activity and not yourself as an individual. Another consideration is whether or not you are truly running the company alone or if you have a co-founder. So as soon as it's more than one person, you kind of want that structure in place. So a good place to start, even before you have your corporate filing, is to consider a founders agreement with whomever, or some people might call it a partnership agreement, but something that lays out the role of the co-founders. This can set you up to avoid disputes in the future. So what are the particular roles of each founder? What are the goals of the company? You can actually put some metrics in there and try to, it's sort of like a light business plan in relation to how you and your co-founders will work together. I actually had a situation about a year ago where there were two founders who had an idea for a company. One was more of the ideas and development guy, and the other was more of the money guy. And in their negotiation over their founders agreement between the two of them, they actually never got past that stage. So while it was very disappointing for both of them, it also prevented what could have been a really messy breakup down the line. So you always want to be able to vet out your co-founders in the early stages. Another thing to look for, traction, have investors come your way saying, hey, I actually think I might want to put money. Are you raising it? Are you raising? As soon as you start hearing that, you want to make sure you've got your corporation set up, because you definitely, especially in this fundraising climate, need to strike when the iron is hot. And if an investor comes up to you and says, hey, I'd like to invest in your company, and you don't have your company set up, you obviously can't take that investment in yet. And one last thing to consider is intellectual property. So if you're doing the development yourself, that's one thing. But if you're using independent contractors or family, friends to write code for you, you need to be very careful to make sure that that IP is being assigned to you as an individual, and then that you will later transfer that from yourself to the company. But it is much easier to have the company set up and have the IP immediately assigned to the company, rather than having you as an individual be that in-between conduit.
And as a reminder, which I think that's something we had covered in our prior presentation, but once you're incorporating or once you have a structure, even an LLC, but so for a corporation, remember that it has a legal personhood. So it can be sued, and it can incur debts. So as attorney, we work for the corporation, and so do you. The more shareholders they are in the company, the more this is even true in that as directors of a corporation, you will have to do what's in the best interest of the shareholders, all the shareholders, and not just as the directors or the founders. So that's something to keep in mind, that at this point, the corporation is really its own person. So. And I think we had one question again on this registering in different states. Do you need to register your company in other states if you sell physical goods online? So every state so usually you have to register when you're doing business in a particular state, and the definition of doing business varies from state to state. So there might be some monetary thresholds. There might be if you're targeting specific customers in a state. So there are different factors, and that's really on a state-by-state analysis, whether you would have to register in that state or not. You probably would have to collect sales tax for states. So, I mean, I guess at some point, it's also about like the volume of sales from a particular state. And when you do your online marketing, how do you target the customers? If it's by region, for example, then that's something also to consider.
Yeah, and that's one of those areas that leaning on your tax accountant or those types of folks is really good, because we will occasionally file business licenses in different states, but when it comes to Johanna's point about collecting sales tax, you definitely want to check with your CPA on that. So there's a question about structuring your startup for investor attraction. So going back to what I was saying, striking while the iron's hot, what are the very basics? Have your company incorporated, sort out what you want the equity split to be between the founders, and get those stock purchase agreements signed. Also, establish your employee stock option plan, or at least know how much of your option pool you want to set aside for those early employees. And basically just, you want to have your ducks in a row. You want to have the corporate formalities taken care of. So use relatively standard docs, nothing super weird. In the early stages, an investor probably is not going to ask to see everything. But once you get into that seed and A round, that's when you're going to have some investors' team of attorneys ask you for your data room. And if at that point they realize that you have failed to take some corporate formalities, you will either lose the investment opportunity, or you'll end up spending a bunch of money fixing some of those early corporate problems.
And I think we also had some questions. So I think, yes, the where to incorporate, but that's something we've addressed earlier on. There was another question that comes up often is the differences between corporation, SCorp, and sole proprietorship. So this we can go like the difference between a C Corp and an S Corp. It's a tax question. So when you incorporate your entity, you don't select whether it's an S Corp or C Corp at this level. It's a corporation, and then by default it would be a C corporation, and then if you wish to have it as an S corporation, then you have to make a particular election with the IRS to be treated as an S corporation. So S corporations are better for companies that are like more like family, or not family companies, but not necessarily for investors, but where you will have few shareholders. The reason is you have limitations for an S corporation. Number one, the shareholders must be US citizens or residents, so you cannot have foreign investors, for example. Second, they have to be persons, human persons, so you cannot have entities as shareholders of an S corporation. And there are also a limitation as to the number of shareholders, which last time I checked was 100. I would have to double check. So it's really meant for smaller corporations, and it gives, once you're an S corporation, the company is treated as a partnership for tax purposes. So again, we're going back to taxes. And so it has the same pass-through mechanism as an LLC. And so there is no double taxation as you would have for a C corporation. So this would be the main the main differences between the two. And what a solo proprietorship is, it's really it's an individual doing business without an entity structure. So nothing registered as a partnership or limited partnership, LLC or corporation. So if I were to do business on my own under my personal name, then as an individual, then I would be a sole proprietorship. That's so there's no structure. It's not necessarily recommended because you don't have a protection from personal liability, which you would have once you incorporate as a corporation or organize as an LLC.
Great. There was a specific question about the optimal business structure for consultants. So analyzing the best fit structure to align with the needs of a consulting practice. So consultants do generally utilize an LLC. If you have a license like we do, a legal license or a CPA in California, you can form a limited liability partnership. But that'll vary from state to state on what types of professionals are eligible to file an LLP. But yeah, for consultants and folks who are not trying to take on investment money, the LLC often makes sense. So going back to Johanna's first points here, a lot of this just comes down to the question, do you plan on taking in outside funding or not? Okay, so there was a question about changing your business structure from a sole proprietorship or an LLC into a corporation. So this is a bit of a complex question. So I can briefly go through some of the steps, but this is definitely something that you would want to have help on. And as a preliminary matter, you're definitely better off knowing from the beginning what your long-term business goals are and picking the corporate form that is going to match those goals. So I've seen some founders say, oh, well, I'll just form an LLC now because it's easier, and then I'll create my C Corp later. If you're already planning to file a C Corp in the future, just do that in the beginning. So if not, and you have your LLC, one of the first things to consider is this a single member LLC, meaning it's just you, or do you have multiple members? If it is a multi-member LLC, then the first thing you're going to need to get is approval of those other members. That approval may or may not come easily if some of them do not wish to convert to a C Corp. Next, you're going to have to file specific documents with both the California Secretary of State and the Delaware Secretary of State. You're going to have to get together all new corporate documents for the Delaware C Corp. So all of the standard articles of incorporation, bylaws, etc. You will need to adjust any contracts you have with vendors or with your employees to now be in the name of the new corporation and not the old LLC. And you also need to update the IRS on that. Something else to consider, though, is an asset sale, which is an alternate way to do this, which is basically where you create a Delaware corporation, and then that corporation purchases all the assets and liabilities of the LLC. So the word conversion can be a bit misleading because sometimes it's more of a structured buyout than anything else, but it can certainly be done to go from an LLC to a C Corp. But I would say that if it pops in your mind that you have an LLC and you might want to change it in the future, do it quickly so that you don't have a bunch of different members of the LLC to try to coordinate on that move. And definitely talk to both an attorney and a tax professional, because like Johanna was mentioning, the LLCs, there with the pass-through taxation, that's going to be coming only at the personal level, whereas the C Corp is going to be both the corporation and the personal level. So you are going to want to know how that is going to affect your personal taxes.
I'll just go with Joa's first question before getting to the doing business GBA's question that we received earlier. What paperwork is important for for investors to see during seed and Series A? Well, they would. Well, you want to have your corporate documents prepared, and by corporate documents, it would be the charter documents, which include articles of incorporation, bylaws, founders agreement, meaning when you have a founders stock purchase agreement, they would want to see this. If there are some vesting schedules for certain shares that have been sold, then they would want to see this. And I mean, then some financials, but that's something more of an accounting question. If you have some ISOP, like stock option, they would want to see this. Basically, having a good idea of making sure that the corporate formalities have been followed. Also it's always good to have ready a capitalization table, what we call a cap table, because these are very often, they are asked regularly. And if you don't have one ready, it takes a little bit of time if you have to trace back who owns what. And so this would be the main document that they would ask to look at, in addition to a deck and business plans and so on. But just making sure that the corporate formalities have been followed, that the franchise tax has been paid every year. And also, as a corporation, you have to have annual minutes, directors and shareholders. So it's good practice to have these ready, and also for every single year that the corporation is doing business. So if you incorporated in 2022, make sure that as of the date of the incorporation, so the anniversary, you also have annual minutes signed. They're just they're not complicated, but it's good practice to have them there. Then I think we had a question on like DBAs, business names, fictitious names, trademarks, understanding the roles and the difference. So the business name it means a lot of things. You have the name of your company. That would be the name of the corporation as registered in a state, California, Delaware, Nevada, Texas, and so on. Usually that gives protection for that business name in that state, meaning if you have another company that wants to register in the same state with the same name, they will not be able to. And so that gives like a state protection. And then you have DBA, fictitious name. Yes, so these are the common names for those attributions. These are registered at the county level, and the protection is also at the county level. So if you're in LA and you want to have a DBA, then you would have to file this with the LA County, the recorder's office. And there are some requirements for a DBA. For example, some years ago, I was working on filing for DBAs in Texas, and the rules were similar. So not that I know all the 50 states, but they're akin. Usually, it's better to use a third-party filing service because they do this a lot, and they're very efficient. And having a legal counsel the cost of legal fees would not be justified here. It's like a 1 or 2 page form where you need the name of your corporation or your entity, the business name or the doing business as that you wanna have, and then there will be like some publication in a newspaper for 4 weeks, and after that the name would be registered, and you would have protection for California is 5 years. Sorry, Los Angeles is 5 years. Would have to check on a county by county level. But again, it only gives protection at the county level. So sometimes people do DBAs for if the name of the company that they wanted to have doesn't exist, or if they have a specific line of business. So if they have many lines of business under one corporation and they want to distinguish them, then you can have different DBAs. That way you can market a specific line under that DBA without having to change the name of the corporation. And then you have trademarks. So trademarks, these are protected when registered at the federal level, they are protected country-wise. So wider protection. And it's not just the name, you also have protection for the mark, the logo, and it's limited per class of services or class of goods. And so that it's usually you either need to be using the mark or the logo, or you need to use it within 6 months after filing for the trademark with the USPTO. And usually, so it's registering a trademark is pretty straightforward. But there are third-party services that also do it in an automatic way. For example, we often work with a trauma TM, which actually does the registration. And because before doing a registration, you also need to check that the name is not already taken for that particular class. And so it's good to have those third-party services run that search for you.
Yeah, I had a particular situation come up a few months ago where a client came to me because they were very frustrated to see that another business had the same name as them and a potentially similar logo. And this, it ended up costing both parties a bit in going back and forth and drafting and agreeing to what's called a coexistence agreement. So if you end up having this clash with another company with the same name as you or the same or a similar logo, filing with the patent and trademark office to try to have a trademark rescinded is a really difficult process. So you then try to work out some sort of coexistence agreement, which is essentially to say, hey, your company can use the same name as our companies, but you need to stay in your lane. So you do these things, we do these things, and we are not going to have businesses that are competitive with each other. There were some questions about equity. Specifically determining the equitable distribution of ownership among the founding team members and practices and methodologies for arriving at fair equity splits. So this is a really tough thing to sort out. It kind of goes back to that founders agreement I was mentioning earlier. You want to have an honest conversation. Firstly, is there a head honcho? Is there somebody who's really steering the ship and should be the majority equity holder? If so, then if it's you or someone else, that person often will get the greatest share of equity. But we often see that founders want that equal kind of buy-in across 2 or 3 folks. So they might split it equally. If it's 3 people, that's generally fine because you have a natural tiebreaker built in there where you will always have a majority to make a decision. If it's 2 people and you split it 50-50, then you can end up at a deadlock in terms of corporate decision making, and you will have to build in some sort of provision for breaking those ties. Other general things to consider are people putting their own money in? What kind of time are they dedicating to the project? What intellectual property is being provided to the company? What are the skills brought to the table? Who do you foresee will go out fundraising? So these are things that absolutely talk to your advisors, your mentors, your business coaches, and then have a very frank conversation with your co-founders about kind of who's in this for the long haul and what do you want your involvement to be. A very unfortunate reality is that money can change the way that people act. We see this all the time, that once the company starts making money, the founders end up having a disagreement and somebody needs to be booted out of the company. For that reason, it's also good to have vesting schedules, even for founders. Sometimes founders say, oh, well, we're the founders. We want to get all of our equity or all of our shares up front. That is not a good idea when you have multiple founders, because then you have a much more difficult time getting somebody out of it. Also, it might show to an investor a lack of long-term commitment to the company. So they want to know that you're not going to just take your equity and run, that you're actually going to stay with the company for a long time, because your skin in the game is only going to increase over time. And the last thing is just when you're calculating out your equity, think hard about how much should be available for founders and what amount you want to put aside for your employee stock option pool. So there's some pretty standard percentages that you can find online or from advisors that you have as to how it should be divided amongst founders, investors, and employees. Okay, we had some IP questions, just generally about establishing robust IP protection measures. So like we said earlier, having your corporation formed and having the IP that is created by your contractors and employees is super important. So everybody's going to sign a invention assignment agreement, a PIAA, and you want to make sure that even if this is the very earliest days of your startup and you have very few formalities in place, get a contract together that says that any intellectual property created will initially belong to you, and then as soon as you form the corporation, it's going to go to the corporation. Or in the alternative, you can have an agreement that says once the corporation is formed, the IP will automatically transfer to there. But this is something that's kind of easier dealt with when you already have the corporate form created. There's a related question about trademarks and patents and grants. So I will say that grants are super specific. So you want to consult with somebody who deals with grants from foundations or from governments. But good to remember that it can be an awesome source of funding because you do not need to give away equity. So if you're in the type of industry that is eligible to receive grants, that's absolutely something worth looking into.
Now we had a question on advisory board and exploring the advantages and considerations associated with instituting an advisory board within a startup setting. So advisory boards, personally, I think they're a good thing. They may come up with advanced investment rounds. So once you're getting into probably more like Series A, and when you're starting to issue preferred stock to investors, they want to be able to see how the company is being managed from the inside. And so often they would try to have some seats at the board. It doesn't mean that you're losing control. It just means that they want to see what's happening. They want to see how it's managed, how the decisions are being made, and how are the finances handled. And it can also be a condition for an investment. So you can, the more advanced you are in terms of rounds, the more you will see investors asking to have a seat at the board as a condition to investing in the startup. And there can be really advantages because you can have experienced advisors. So especially in early stage, it might be good because you may have someone who has already worked with like 3, 4, 5 startups before and knows more of the pitfalls, or can elaborate some strategies or help the growing of the business. So advisory boards are so long as they're structured in a manner that you don't lose control on the decision-making process, then I don't see anything negative about having an advisory board. And then we also have some questions on employment. So employment, it's a state by state question or a state-by-state response in that every state has their own labor laws, except for the main federal ones. But we often see early stage companies, startups, having a lot of independent contractors as opposed to employees. So they're the main difference, I mean, aside from not paying employment taxes for independent contractors, you want to make sure that they are true independent contractors, meaning like you want to avoid any misclassification for purposes of labor laws. And every states have their different factors to determine whether someone is an employee or an independent contractor. Very often it comes down to whether who has the control over the means of work. So basically, if you ask someone to log in on their computer at 8 a.m. until 5 p.m., you provide with their computer, and they have very specific tasks of what to do, when to do, most likely it will be an employee. An independent contractor would have more freedom. For example, it would be like a task by task. Let's develop this website within the certain timeline, and then they have the freedom to execute the work as they wish. More like it will more likely be an independent contractor. One thing to really keep in mind is that if you're hiring 1099 independent contractors and there are some IP works related or some work that is being created, make sure that in the contract with that independent contractor, there is a clause saying that the work, the intellectual property rights are belong to you and are assigned to you. Because although you may have a default law on this for employees, you don't necessarily have it for independent contractors. So that's one thing that's kind of important for startups to keep in mind. So we also see a lot different for independent contractors and employees when it comes to stock options. And so not that this is necessarily within the scope of this presentation, but we often have the question being asked to us. And you can have stock options for employees and independent contractors, usually advisors and so on, but this would be treated differently for tax purposes. So often it comes down to, well, whether at first the company can afford having employees, but also what is the scope of their duties. In terms of labor laws, so whether it's an independent contractor or an employee, there are no mandatory vacation. So it's the US, so no one is entitled to any vacation here. So for some states, employees there are some mandatory sick days. So for example, in California, we do have this, but that is not the case for an independent contractor. So less labor law protections, almost no labor law protections for independent contractors because they're not employees. So which is why at first this is the preferred method of hiring for startups.
Okay, so we do have a few of the pre-sent questions, but I'll just quickly address some of these others. We have about 10 questions left. So we did important paperwork, documents, how do startups ensure compliance with GDPR and CCPA? So when it comes to GDPR and CCPA, so these are privacy regulations, definitely things that are worthwhile using data privacy experts in those contexts. I know somebody had sent a pre-question in specifically about minors. So you have to be really careful when folks are under 18. But the simple advice I can give is to find a company that is similar to yours, but is much bigger and in the public eye, for example, and try to look at what their privacy policies look like. That can often be a very good guide. Also, you want to have a DPA in place, a data processing agreement. And it kind of comes down to how and with whom are you sharing data. So the less anonymized that data is, the more serious your safeguards need to be. what makes a contract binding? The most important sections to be concluded with a contract with a client or customer. So
that would be law school 101.
yeah, contracts law 101, you need an offer, acceptance, and consideration. So you offer something which is accepted by the other party, and there is some exchange of value. So the big thing you hear is no contract absent consideration. So you can't contract with somebody to do something that they are otherwise going to do, basically. So for example, when this comes up often in the context of letting people go from your company, and when it comes time to sign a severance agreement, if you want them to sign an agreement that says they're not going to disparage your company, they're not going to compete, etc., you need to offer some sort of money incentive. So you are giving something. There needs to be something of value exchanged by both parties. There was a question that came in DM about how many different agreements are there. There's really an unlimited number of agreements that you might face. I generally tell my clients, if someone's asking you to sign your name on a dotted line, that's a good time to reach out to an attorney. But when you're in the very early stages and you're trying to have other folks sign agreements, or you're using standard documents, there are templates available online. Cooley Go has a really great resource. Cooley is a leading startup law firm. You could also look at the NVCA, the National Venture Capital Association, for some of their standard funding related documents. And then there was a question about actual formation. So you can use a law firm, or you can use one of these services like Stripe Atlas. We generally find that Stripe Atlas will get you 90% of the way there, but it's not going to create a perfect corporation. But whether it's Stripe Atlas or us or you on your own, there are many examples of standard documents online that you can utilize. When you create an LLC, do you have to get the name trademarked? Yes. So creating your business does not automatically create a trademark related to that business. You also don't have to have the business before you can file for the trademark, but like Johanna said, you have to either be using it in commerce or show an intent to use it and then actually use it within 6 months. Cooley is COOLEY go.com.
And I also received a personal question about is an LLC easily pierced by an experienced attorney? So what is meant by to pierce an LLC or a corporation is to remove that shield from personal liability, and that's what we call to pierce the corporate veil. If you want to, it's not easily pierced so long as the corporate formalities are maintained. And one of course, the key rule is not to mix up the funds, like the bank account and the funds of the company are not the bank account and the funds of the owners of the company. So that's the number one red flag, is using the company's resources for personal shopping or personal expenses. Maintaining taxes, tax preparation, taxes, bank accounts, expense, everything separately is good practice. And if they are, because sometimes you do have transactions between an owner and the company, it's not illegal per se, but you want to have it documented. Because if the company, or if you're loaning money to the company, if it was not your company, you would actually evidence it and materialize it through a written agreement. So just consider this as the same setting as if that company was your neighbor, for example, and just keeping that line very distinct. So that's the best way to make sure it is not pierced. So maintaining the assets are very separate, not using a company car, for example, for your own, for your weekend trips, and so on. So that's the main. So it's not easily pierced, but it's not impossible either if there's some if there's poor management or if the funds of one are used for the other.
We've got a couple minutes left. I know we started a little bit later, so I'm happy to spill over a little bit, but I know we're all busy here. So if there's any last questions, I know there were some that came through beforehand that were a little outside the scope of this presentation. Some other things that did come up about recognizing red flags and errors. So things to look out for. Try to get things in writing as early on as possible, even if you don't have the corporation. Try to have written agreements. I just talked to a founder a few weeks ago who was telling me, oh, well, it's my friends, so I know it's going to be good. I talked to somebody else who said, oh, yes, I've worked with this person before, so she didn't bother reading the contract I signed her. She just trusts me. Neither of those is a really comforting situation. You need to make sure you have things in writing, and you know, being the boss isn't going to be pleasant every day, as I'm sure many of you will attest to. You're going to have to make tough decisions, particularly when it comes to those folks that you were close with even before you started the company. But like Johanna mentioned earlier, when you are running a corporation, your duty is really to the shareholders. So you have to make decisions that are in the best interest of the company and not in the best interest of any one individual, no matter how close you may be to that person. There's question about investor pledge agreements. That's something to talk specifically with an attorney about. I think the NVCA that I mentioned earlier may have some documents on that. There's a question about media of minors on a coaching app. So we covered that briefly with the GDPR CCBA, but like I said, I think with minors, be very, very careful to make sure you have it buttoned up. There's a question about legally merging a family foundation, a nonprofit, and a public facing entity. So, you know, the more different businesses or corporate forms you're trying to merge, the more complex naturally it will be. So, you know, generally when we talk about a lot of corporate forms, you end up creating some sort of umbrella structure, some parent corporation that will sit on top of those other corporate forms. There's a DM that came in about IP assignments being in writing or oral, and that a written contract might be intimidating by some folks. Yeah, I hear this from founders a lot, that, oh, I don't want to send this person the agreement, it's going to scare them. The fact is that it's really hard to enforce an oral contract. Like the question about piercing the corporate veil, as attorneys, that's stuff that we can spend a lot of time battling with and drafting arguments in favor of or against. And it's similar with oral contracts. So if you think that you know, often I'll have somebody come to me and they say, hey, I found this 15-page template, I sent it to my contractor, they don't want to read it. I said, well, okay, maybe we don't need a 15-page agreement. Can we use an 8-page agreement? And if that's still not working, it's okay, well, what are the absolute minimum things we need to get on paper? But typically, once you get past a certain point and it's too short, then you are leaving out some essential components. So I very much suggest that when it comes to IP assignment, you have those in writing, and an oral agreement. You know, the courts, if it gets to that, the IP is your company. You know, that's really at the end of the day what you make your money on. And so if somebody else owns the IP, in many respects, they are the ones who own your company. Great. Well, thank you all very much. This was fun having the questions beforehand. I hope I'll see some of you at the event on Thursday as well. Thank you, Michelle, for having us.
Absolutely. Thank you so much, everyone, for joining us. Again, if you have any questions that did not get answered, please feel free to reach out to me at l@grid110.org or contact Stephen or Johanna. Thank you again, guys, for having such a wonderful Q&A, AMA, all the eggs. We really appreciate your time and your dedication to our community, and we're just excited to keep collaborating in the future. Thank you, everyone.
Thank you. Thank you very much.